All right, everybody, welcome back. Section 14, so close to the end of the semester. We're almost there. You can do it. Stay with me. So, here's our funny internet picture of the day. Yeah, it's funny, right? Prison, don't pick up hitchhikers. Please don't pick up hitchhikers. Bad juju all around. Never works out well. All right, so this section is all about kind of juvenile justice, okay? Again, most of you, if you're within a criminal justice program, you're a criminal justice major, you're going to take an entire course just on juvenile justice. So this is just kind of a small teaser, beginning of the process of getting you to understand that the juvenile justice system is similar to the adult system, but at the same time, very, very different. So America, we've always had juvenile cases, but they're comparatively very rare. Okay, it's the 18 to kind of 25-year-olds that are the peak of criminal offending. Also, juvenile cases are more often dealt with by parents and non-legally. For a long time, if the police picked up a juvenile and it wasn't, anything short of like murder or armed robbery, they would just take that juvenile to their parents and not even deal with it in a legal way. We've always had the defense of youth, right? So there's a certain point where you're too young to commit a crime. You are too young to understand that what you did was wrong. You're too young to have that mens rea. Today, that limit is different state to state, but it is a long tradition in the United States that there are some people who are just too young to hold accountable for crimes. So during the 18th, 19th, 20th century, our population just started skyrocketing. The Industrial Revolution, immigration, all these things have caused our population to go up. As our population goes up, we also become less rural, more urban, get packed into cities, and that increases juvenile crime. Okay, population density is a very good predictor of crime, and that includes juvenile crime. So the more people you have packed into a small space, the more crime you're going to have, the more juvenile crime you're going to have. And there's a lot of different theories as to why that is, social disorganization and, all these different things. But that is what we see time and time again. So with the Industrial Revolution came more cities, more factory work, less oversight of juveniles, and thus more juvenile crime. So in the 19th century, early 20th century, kind of the United States looked at itself and it said, look, these juveniles are not being successfully raised and socialized by their parents. So at some point, the state, the government has to step in. And this philosophy was called parens patriae. It's a fancy Latin term, and it basically means that the government is parent in certain cases, right? So to this day, if parents do very, very, very neglectful things for their children, at some point the government is going to step in and act like the parent because the parents aren't doing their job. Where that line is constantly kind of a matter of debate, but at some point, whether it's starving your kids or ignoring your kids or not giving them the medical care they need or whatever, at some point the government is going to step in and say, no, you can't do that to your kids. We're going to fix this. Remember I said in an earlier section that, way back in the day, when the United States first started, if you were found guilty as a juvenile, you were sent to an adult prison. In 1825, they created the First Reformatory, which is essentially a prison for juveniles, but it's different. It was instead of focusing on punishment, instead of focusing on putting them behind bars instead of focusing on kind of those same philosophies of this is why we punish adults. It took this parens patriae philosophy and said, look, we need to socialize you because your parents failed you. Or at least that was the theory. So they tried to focus on employable skills. Let's teach these kids how to farm. Let's teach these kids how to do woodworking or leatherworking or work in a factory, or teach them to read, teach them to, do all this stuff. But there was a complete and total lack of oversight. Thus, essentially these reformatories, a lot of them turns into places where it was just the adults taking advantage of the children. Could be them taking advantage physically and sexually, could be taking advantage of them monetarily, and kind of using them as kind of slave workers for stuff. There was neglect, there was all kinds of problems. There was also a lack of due process rights. Essentially, any of your constitutional rights that you have as a person recognized by the U.S. Constitution at this time in the 19th century, essentially none of those applied to juveniles. You didn't kind of get your rights. You weren't able to exercise your rights until you turned 18, which obviously caused a lot of problems. Caused a lot of kind of travesties of justice, combined with the very corrupt and negligent reformatory system. The 19th century was not a good time to be a juvenile offender. So, how did that change? Well, first off, in 1899, they created the first juvenile court. So in 1825, they had the first reformatory, but the juveniles who were sent there were all sentenced in an adult court. But in 1899, they changed that. They said, no, we're going to have a court just for juveniles. There are specific problems, there are specific needs, a specific philosophy. We're going to have them separate from the adults, and that's very important. That is the first step in recognizing that criminality in juveniles is different than criminality in adults, and the solutions to the problems are different. So it was a good first step in separating out adults and children. 1966, there was a case called Kent v. U.S. Okay. And in this case, the Supreme Court ruled that if you want to waive a juvenile to adult court, which you can do, so certain states have different rules about how it's done, but essentially if the prosecutor thinks that what the juvenile did was bad enough, if he thinks they committed an adult crime and thus they should go to adult prison, an adult court, they can do that. They can say, even though you're under the age of 18, we're going to waive you to adult court, and the adult court is going to treat you like an adult. Until 1966, that was entirely at the prerogative of the prosecutor. After 1966, the Supreme Court says no. The juvenile should have a right to a hearing. There has to be some kind of ability for them to explain themselves and why they shouldn't be waived to adult court and all these things, and a judge should have to agree with the prosecutor after hearing all the information and stuff. 1967, this was a very, very big one. This might be the most famous juvenile court case of all. It's called In re Gault. A lot of juvenile cases aren't, A versus B. They're just in regard to or in re and then the person. So 1967, In re Gault, essentially, Gault was had a lot of his constitutional rights denied to him, as had been the tradition, because he was a juvenile, and he took it to the Supreme Court, and the Supreme Court says, no, there are certain constitutional rights do apply to juveniles. Not all of them, but some of them. So, for instance, this gave juveniles the right to a lawyer. So just like adults have the right to a lawyer if they're facing prison, juveniles have a right to a lawyer if they're facing the equivalent of prison. Juveniles also had the right to confront and cross-examine witnesses. They had the right to notification of charges, and they had the right to remain silent, just like adults did. Okay, so those all came out of this In re Gault. In 1970, another court case, In re Winship. This case changed the standard of proof required for a conviction in juvenile court. So in adult court, we've always talked about, how you need proof beyond a reasonable doubt, right? In juvenile court prior to 1970, it wasn't beyond a reasonable doubt like in adult criminal court. It was the preponderance of the evidence, like in civil cases. So in 1970, they said, no, you can't do that. You can't criminally hold somebody responsible at the level of preponderance of the evidence. It has to be beyond a reasonable doubt, just like it is in adult court. Okay. 1971, Mckeever V Pennsylvania. Essentially, this one said, the juvenile in this case tried to say, look, I don't want just a trial with the judge deciding my fate. I want a jury trial. And the Supreme Court says, no, you're a juvenile. We have specific, this whole parents patriae thing. The judge is the best decider for what is the best thing for you. Thus, you are not entitled to a jury trial. So to this day, juveniles are not entitled to a jury trial. 1975, Breeds versus Jones. Essentially, they found that if you're tried in juvenile court and found not guilty, you can then be tried in adult court prior to 1975 and found guilty. So essentially, this case says you can't do that. That counts as double jeopardy. Okay. So once you get that not guilty verdict, or whatever the equivalent is for juvenile court, in juvenile court, you cannot then waive them to adult court and try them for that same crime again. That is double jeopardy. Can't do that. Okay. 1984, Thompson V Oklahoma. The Supreme Court says you can't give the death penalty to any person who committed the crime when they were under 16. Then 2005, Roper v. Simmons expands that, and it says you can't give the death penalty to anybody who committed the crime when they were under 18. There is no way that somebody under 18, I don't care how close to an adult they are, they don't have the mens rea capability to deserve the death penalty. Okay, so now any crime committed when you're under the age of 18, can't give them the death penalty for it. And then in 2010, Graham v. Florida, it says not only can you not give juveniles the death penalty, you also can't give them life without parole unless it's homicide. So Graham was a juvenile who committed, I can't even remember what he committed. It was a fairly harsh crime, but it wasn't murder. It was like an armed robbery along with something else and something else. And because of Florida's laws, he was under 18 when he committed the crime, but he was tried as an adult and he got life without parole. So Supreme Court says no. He committed the crime when he was under 18. You cannot give life without parole to anybody who commits a crime under the age of 18 other than murder. If they commit murder, it's a possibility. You can theoretically give them life without parole, but anything outside of murder, no. You have to give them the opportunity for parole if they committed that crime under the age of 18. Make sense? These are all very, very important court cases. I would totally recommend reading up more on a lot of these because they will give you a much better idea on what juvenile courts are like and how the juvenile justice system is different from the adult system. But we are going to end this subsection here, and we'll be back with the next subsection momentarily.